to the media to leave the room, and we're seeing that happen at the present time. Appreciate that. We want to thank the Minister, the Honourable Diane Finley, for being here with us. This is our second meeting on the budget bill, Bill C-50. We want to thank her for taking the time to be able to be here and answer the questions of the committee. Are you sure it's a point of order?
It's a point of order.
It better be.
Yeah. Okay. I think out of respect for your kids, I think you should say hi to your son and say hi.
Okay, I'll do that. Actually, actually, my son and daughter-in-law are in the room. They wanted to come, and so I do want to thank them for coming to Ottawa and being here. Yeah, that's right. It's a new thing. They wouldn't. I knew you'd be easy on me after that, so I do appreciate that support. Nonetheless, we want to continue with the meeting. We thank the Minister for being here and taking the time. We have her for an hour, and then we have some of her department staff, and you have some of those with you at the present time. So with that, I'm not going to take any more time to introduce anyone here. We will start with the Minister's. You have 15 minutes, and then we will move to question and answer. The floor is yours, Honourable Minister.
Well, thank you, Mr. Chair. Merci, Monsieur le Président. Je tiens à remercier.
I would like to thank the committee for this opportunity to speak on the immigration provisions of Bill C-50, also known as the Budget Implementation Act. With me today are my Deputy Minister, Mr. Richard Fadden, and my Assistant Deputy Minister, Mr. Andrea Lyon.
Minister of Citizenship and Immigration, in a government that recognizes that immigration is as important to Canada's future as it has been to our past. Our country was built on immigration, and our future prosperity and success as a country largely depends on it. Because immigration is so important to Canada's future, we need a modern and renewed vision for immigration. By 2012, all of Canada's net labour force growth will come from immigration. And the stark reality is that if we do nothing to address the backlog, pardon me, by 2012, applicants will face a 10-year wait time to have their application processed. And the lineup of people waiting to get into Canada could easily reach upwards of 1.5 million. Now, contrary to the previous government, we do not believe that the status quo is acceptable. We're facing real and serious international competition for the talents and the skills that we need to fill the jobs that are waiting to be filled here in Canada. Whereas Australia and New Zealand are processing applications in as little as 6 months, it can take us up to 6 years to even begin looking at one's application, let alone process it. The result is that there are approximately 925,000 people now in line waiting to immigrate to Canada, with almost 600,000 of these people applying in the skilled workers category. And when we compare ourselves to the United Kingdom, Australia, and New Zealand, we are the only country that does not use some kind of occupational filter to screen applications. This weakens our ability to select applicants who would be best placed to succeed in our labour market. And as a result, only 10 to 15% of skilled workers admitted here have a job arranged when they arrive, compared to over 80% of similar immigrants going to New Zealand. Nous pouvons tirer deux conclusions de cette situation.
And draw two conclusions from the situation. First, that we risk losing talented people to other countries, talented people that we need right here in Canada. And second, the current system is preventing immigrants from getting the best possible start in their new lives.
It's unfair to our country, it's unfair to immigrants, it's unfair to those waiting for a response to their applications, and it's unfair to the families here. So it's time to act. We have a problem and we need to address it, and that is precisely what we are doing. Currently, we are required by law to completely process every application, regardless of how many people apply or how many we're able to accept. And, under law, we are obliged to process applications in the order in which we receive them, with just a couple of exceptions. The current system, if left unchanged, is on track to collapse under its own weight. So the system needs fixing. Urgent action is required so that we can bring more immigrant families here faster and more skilled workers here sooner. So to address these challenges, we're taking a three-pronged approach. First, we've committed to investing more money to address the backlog, $109 million over 5 years. And this funding will allow us to hire and train more visa officers to speed up processing in parts of the world where wait times are the longest. But increasing funding alone is not enough. We need to do things smarter, better, and faster. In addition to increased funding, we're making administrative changes to increase both our efficiency and our effectiveness. Sensible things, like centralizing processing, improving and enhancing computer systems, sending in SWAT teams to tackle local backlogs where we believe that they can make real progress on them, and transferring files from very busy to less busy missions. Third, through Bill C-50, we've introduced legislative changes that will give us the flexibility and the authority to both manage the backlog and set priorities that will match Canada's needs. Our proposed legislation will allow the minister to identify categories of occupations, not individuals, which will be processed on a priority basis, based on our country's needs, not based on one's individual place in line. And to make sure that we get these categories of occupations right and fair, we're placing several checks and balances on the minister. I like to call these controls the 3 C's, the Charter, consultations, and Cabinet. Les instructions ministérielles seront...
The ministerial instructions will of course comply with the Canadian Charter of Rights and Freedoms. They will maintain a system that is universal and non-discriminatory, and these instructions will also require broad input.
The provinces and territories, industry and government departments to shape the approach every step of the way. And our consultations with the provinces will include getting reassurances from them that if regulated professions are on their list, they will have commitments from their provincial regulatory bodies that these individuals will be allowed to work in their chosen fields once they get here. Enfin, les instructions ministérielles.
And finally, ministerial instructions will be subject to Cabinet approval, and I can assure you from previous experience that this is not a simple rubber stamp process.
Will put too much power in the hands of the minister without sufficient accountability. For example, there is a myth out there that the minister will be able to arbitrarily cherry-pick applicants in the queue and override visa officers' decisions on individual cases. This is simply not the case. The legislation will not allow the minister to override or reverse individual decisions to admit someone who has been made by visa officers. Our immigration officers will continue to make decisions about individual applications. And with respect to concerns being expressed about the impact of this legislation on family reunification and on humanitarian and compassionate cases, any instruction from the minister will have to respect the objectives of the Immigration and Refugee Protection Act. These objectives include supporting Canada's economy and competitiveness, supporting family reunification, and upholding Canada's humanitarian commitments. So to be clear, the ministerial instructions will not apply to refugees, protected persons, or humanitarian and compassionate applications made from within Canada. Elles respecteront également les engagements que nous avons.
The instructions must also respect our commitments to provinces and territories regarding the Provincial Nominee Program and the Canada-Quebec Accord, a vision that will allow this will be transparent and published in the Gazette and reported in the Citizenship and Immigration Canada's annual report, which is tabled in Parliament.
Is that under the proposed legislative changes, we will not have to process every application. Those applications not processed in a given year could be held for future consideration or returned to the applicant with a refund of their application fee, who would be welcome to reapply. The result, Mr. Chair, will be that the backlog will stop growing and actually start to come down. Now, some have rightly asked why these immigration provisions have been included in Budget 2008. Well, it's because our government recognizes the critical role of immigration in the Canadian economy. Our government underlined the importance of immigration in our government's blueprint for economic growth and prosperity, known as Advantage Canada, in Budget 2006. The immigration provisions included in Budget 2008 build on what we said we would do in Advantage Canada in Budget 2006. Advantage Canada acknowledged that people are key to having an economic plan that will make Canada a world leader today and in future generations. And that's why we included amendments to the Immigration and Refugee Protection Act as part of the budget implementation provisions. Doing so serves the best interests of immigrants and their families, Canadians, and our economy. En résumé, Monsieur le Président.
So to sum up, Mr. Chair, our proposed measures will give us the flexibility to choose the skilled workers that best fit our needs without affecting our objectives regarding family reunification or refugee protection.
Our government is proposing will ensure fairness by helping us to make decisions on cases faster while meeting the immediate requirements of Canada's labour market. Our goal, Mr. Chair, is simple: to give Canada some common sense tools to reduce the immigration backlog, to do it in a way that meets our needs, and to do it in a way that is fair and which respects our laws. It's about a vision for our country that makes sure that people who have gone through so much to get here find the opportunities to build their families, contribute to their communities, and excel in their chosen fields. A vision that will allow Canada to develop a system with the flexibility to supply our economy with the people that we need to support our growth. Je vous remercie encore une fois de m'avoir.
Thank you for this opportunity to address the committee. We would now be happy to take your questions.
We'll now move to the question and answer portion. Now, I'll remind the committee that when the minister is here, we have all of the opposition. We have a round of 7 minutes each. With the minister's time, the last time a previous minister came, we decided to collectively use 5-minute slots. I don't know if that's the way you want to proceed. If not, we'll stay with the standing order. Standing order? Fair enough. Mr. McCallum, you have 7 minutes.
Thank you, and thank you, Minister, for spending some time with us this afternoon. I'd just like to begin with statistics from your department and ask you to confirm if you agree with them, that in 2005 there were 262,236 landed immigrants. In 2006 there were 251,649, and in 2007 236,689.
Those numbers are approximately correct. I don't have the details, but roughly.
Okay. Then, if those numbers are correct, why did you state that last year your government brought in 430,000 new Canadians? I mean, I can only infer that you. Does this mean you consider students or temporary workers to be new Canadians?
Well, one of the challenges that we have is that older applications take almost twice as long to process as new ones for permanent residents. In the meantime, and we have a finite pool of resources.
No, I'm just talking about the number.
I know. I'm trying to explain the number to you. And so that doesn't meet the needs of business. So we've very deliberately expanded the temporary foreign worker program to get the workers here that we need, because we can't access them on a skills basis in the current backlog under the current rules. Not only that, but we also include in that foreign students who have come here, because as we announced in Budget 2007, both of those streams will be forming part of the Canadian Experience class, wherein certain individuals within those classes will be allowed to apply for permanent residence.
I guess my question is a narrower one. Temporary foreign workers or foreign students, most people would not define those individuals as new Canadians. Would you include them in the definition of new Canadians?
We are making it possible for them to be new Canadians. We are adding them to the stream. We're deliberately blurring the line between permanent and temporary so as to meet the needs of our economy. And we've developed a number of programs to make that happen, including the Canadian Experience class, which will be launched this summer.
Well, thank you. I just do not think that those people at the moment of their arrival are new Canadians, and therefore I think the 400,000 number is inflated, and the correct numbers are the landed immigrant numbers, which I quoted. But let me move on now to questions of money, and this is the Finance Committee. And I would have thought that success in cleaning up a backlog requires resources to have more people to interview and process those people. Now, I understand that you're putting in $22 million over 2 years, which is little more than 1% of the budget in each year, whereas we in 2005 had committed a $700 million plan to reduce the backlog over 5 years. So there's an order of magnitude difference in the amounts of money. So how can you credibly say that you're going to significantly reduce the backlog when you put so little in terms of new resources into the system?
Well, quite frankly, throwing resources at a fundamentally flawed system is just pouring money down the drain. We do need to put more resources to it, but that's not enough. We have to do things smarter and better and faster. So that's why we're making administrative changes, upgrading computer systems, changing our operational techniques for processing. But also, the key here is that we cannot control how many applications we receive in a year. They can come flooding in, and indeed, every year we receive more applications than we have the capacity to process by a significant number. And because the existing law requires that we process each and every application, even if it's a second, third, or fourth application that's been waiting in line for somebody who's already been admitted, that's a waste of time, it's a waste of taxpayers' money, and it's certainly not fair to the others who are in the line.
Well,
so we need to make some structural changes to the system.
I don't disagree with structural changes. I would submit that a trivial increase in resources, even with the structural changes, is not going to make a big dent in the backlog. But I would now like to go on to talk about, to ask you about family class. My understanding is that you are saying that your new rules, which you yourself can determine, you do not intend to include the family class, but that the legislation would give you power to do so if you wish to limit the number of family class people allowed to enter the country. So I guess my question is, is it your intent not to disturb the status quo on family class? And if it is your intent, why are you putting these new powers into the bill when you say that you will not use them?
Well, I'd like to create what perhaps a misperception that was just stated. And you said that we would be limiting family class. That's not the intention here. When we set priorities on categories, they're to give those groups priority processing. All right? That's a very big distinction here, and I'd like to make sure that we clear up some of the myths that have been propagated. When we're setting categories, our intention right now is on groups of occupations, ones that meet the country's needs, ones that will be identified and determined only after extensive consultations with the provinces, territories, industry, other government departments, and approved by Cabinet. That's what the intention is here, is to match the portion of our skilled workers to the economy's needs.
Yes, but my point, I guess, is when you're putting in negligible additional total resources, when you state clearly you're giving a high priority to people who meet economic needs, the inference is, in relative terms, it's a lower priority to family reunification. That is how people are reading it, and I can't see any other way in which to read it. If you have essentially changed resources, higher priority to one group, it must mean if you're fast-tracking one group, you're slow-tracking another group, which is the family class. So I go back to my question. It seems that if you emphasize the economic side, which is fine, you're putting high priority on workers, so essentially you're putting more priority on newcomers as commodities, as workers, rather than newcomers as people. So I ask you again, on the family class, how can you deny the implication that this group is relatively disfavored when you're putting the maximum favor on the economic class? And why do you insist on new powers in this area?
Well, we're actually putting $109 million in extra resources, and most people wouldn't call that either negligible or trivial. $22
million over 2 years.
$109 million. And we're doing that, as I said, to address the 60% who are in the skilled worker class. 60% of the applications, round numbers, are skilled worker. Of that group, 80% are their families, only about 20% are workers themselves. So over 80% of the almost close to 90% of people who are in the backlog are not the targeted skilled workers. And we've already made progress on reuniting families. We've improved processing times over your government by up to 40% because we are making families a priority as a government. We've done that in a number of fields. I was the minister that brought in the universal child care benefit. So, that as an example. We do have a priority on family reunification, and yes, you're right. If at a future point in time we decide that is the priority, they could be fast-tracked, just like any of the worker categories.
Thank you very much, Monsieur Laforêt.
Merci, Monsieur le Président. Bonjour, Madame la Ministre.
Thank you, Mr. Chairman. Good afternoon, Madam Minister. Before putting a question to you, I would like just to make a comment. I am disappointed, and my party, the Bloc Québécois, is also disappointed with the fact that we think that the Conservative government went about things in a devious way, just as we saw in the United States recently, to introduce measures to accelerate the immigration process and to insert that in a bill on the enactment of the budget. And you could say that there is some connection to the Canadian economy, but you could have made the distinctions and separate the budgetary part. So we're wondering about the transparency of your government in this regard. And I know that you just mentioned the administrative agreement currently enforced with the Quebec government. And I don't know if you can answer this question, but do you think that what you propose in this bill will change anything in the agreement between the Quebec and the Canadian governments? Not at all. I spoke to the minister in Quebec, and my officials spoke to their counterparts in Quebec, and we all recognize that these amendments will have absolutely no impact on the Canada-Quebec agreement. It is very clear, and the Quebec government also agrees. So no change? No, there's no change. Question. When you say that by introducing this in the budget process, this is because you want to accelerate things for the employability of immigrants and to give you discretionary powers to react to the needs that might arise in Quebec and Canada, especially in Canada, because you said that in Quebec it would not apply. But you know that for the Immigration Commission and the refugee status, we have commissioners and about 50 vacancies in commissioners' positions, a large number of vacancies, which is a very important link in accelerating the entrance of immigrants. So how come since 2006 you only appointed 27 commissioners? We still have 50 vacant positions. So didn't you not create a problem by not accelerating this process? And everyone agrees that there's a huge backlog, but you didn't really take any preemptive measures to avoid this. These are two entirely distinct problems, entirely distinct. The refugee system is entirely separate from the immigration system. The Canadian High Commission for Refugees is in charge of refugees, or the province of Quebec as well. So when we came to power, there was a system for appointing High Commission members. that didn't have the standards that we were expecting, so we changed the nomination process, and we require that the candidates pass an exam. Previously, there was no such requirement, but we want to have members who are competent and who have showed their skill. And we've already appointed more than 100 persons to the Commission, and we're going to nominate quite a few others. Thank you, Madam Minister. I'd like you to tell us now, I need a bit of information, how many immigrants are coming into the country at this time, and how many come to Quebec out of that number? Each year, 241,000 in Canada, and I have no figures for Quebec. 241,000 in Canada at this time, and about 40,000 permanent residents. But for our future, temporary workers and foreign students will qualify for permanent residence, and they must be included. Let me come back to the Commission. But about a third out of 156 positions are vacant at this time, so I wonder how come things are not going faster in appointing these people when we know very well that the former president, Mr. Fleury, left his position in March 2007 and had 80 candidates on the list, the number of candidates that he could basically appoint. And once again, out of the 80 candidates, there's still a gap of 50. Back in those days, it was much easier, far easier to become a member. But now you have to sit an exam. And the success rate is only about 30 or 40%. It is a very tough standard because we want to have qualified and skillful members, and we have an exam to determine whether they are competent. And the rate of success is about 30 to 40%. It's very difficult to find qualified people.
Ms. Chow, the floor is yours, 7 minutes.
Thank you, Mr. Chair. Adrian Clarkson, our former GG, his father came from Hong Kong, same place where my father came from. Under C-50, his application probably will not be processed. It will be returned every year. He can apply, but his application probably won't even be considered because you now have the right to pick winners and losers. Losers including people like Tommy Douglas, voted the best Canadians. So really, in your definition, what are losers? Why are these people losers? Because you're going to have winners, you're going to have losers. And they're the ones like the Tommy Douglas and Adrian Clarkson.
Well, right now, first of all, we won't be able to pick individuals. I thought I had
Category
made that clear.
of people, though.
Even under categories.
And we
have a finite capacity to accept people now. The difference is they get invited here based on where they are in line and if they have the patience to wait it out to come to Canada.
Who are the losers in your category? Because you're going to fast track some and then you're going to leave some behind. Who are you going to leave behind? The ones in your mind that are not, quote, skilled.
The ones
they are the ones that are not skilled. They won't fit under this criteria. They will be left behind.
The ones that are getting left behind right now are waiting 6 years. They may have to wait 10 years if we don't do something. They're getting left way behind. Not only that, but because it takes so long to get accepted into Canada, 6 years versus 6 months. And
I totally agree with you.
A lot of very qualified people are getting left behind because they won't even bother applying to come here because they don't stand a chance of getting in a timely manner. That's what we're trying to correct.
Right. Those that are waiting a long time, I agree, is a problem. It is an old problem that came from the former Liberal government.
That's what we're trying to fix.
It made it worse. You have ads out there saying that, oh, you're doing all this because of the long wait, okay? Mm-hmm. But this won't come. They are deceptive, these ads, because this C-50 won't have any impact on the 925,000 applicants that's backlogged, because even if this bill passed, it won't come into effect. It won't have any impact to those that are before February 27th, 2008 anyway. Yes. So there's no backlog on visitor visa, student visas, work permit, and yet your C-50 said that you have the right, or your department will have the right, to take these applications, even if they are qualified for a visa, you're taking their right to a visa. And there is no backlog. Why would you change this rule that would impact on everybody else? It doesn't make sense, and these ads are deceptive. Right. And the community are saying it's damaging, it's dangerous. And yesterday I heard even another D word, which is dumb. So you have your 3 C's, and the community has 3 D's, and that seems to be the comment out there.
Well, I guess a couple of things we need to clarify. Number one is there are millions, literally millions of people in China and in India alone who qualify for admission to this country. That doesn't mean that we can accept them all. We have a finite capacity to absorb newcomers, whether it's because of our settlement funding, which we have dramatically increased, but more importantly through things like our hospitals and our infrastructure and our housing and jobs for these people. We cannot accept everyone who is, quote unquote, qualified to come here. And coming here isn't a right, it is a privilege. We have a finite capacity to process the applications and to accept these people and to have them be successful.
Madam Minister,
so we have to recognize that, and with the backlog, the courts have ruled that we must process existing applications under the rules that were in place when they made the application. We'll be following the law. But that's where a lot of our extra resources are going to go, is to getting at that backlog. And we're going to be doing things smarter and better, because if we can put more people on the job, doing the job faster, we can get that backlog whittled down, especially
Madam Minister, I just don't want to run out of time.
Yeah, no, it's fine.
My friend will be mad at me.
I realize you want to split your time with Mr. Mulclair. We'll allow that. You have 2.5 minutes.
Merci beaucoup, Monsieur le Président. Monsieur le Président.
Thank you very much, Mr. Chairman. Mr. Chairman, several times during her intervention, the Minister said that this is not what we intend to do. This is not what we want. Does she realize that by saying that, she's actually admitting that it is a possibility? Does she realize, just as the president of the Association des Avocats from Quebec stated the other way, that one of the most important changes in the bill is that a system is changed into a purely arbitrary system, haphazard system, open to discrimination, and the criteria are entirely arbitrary. And this is exactly what the various cultural communities are concerned with. Can you understand that? No, not at all. It is forbidden to make discriminatory legislation. We have a Charter of Rights and Freedoms, and the governments, the departments, and even the ministers must recognize and observe the Charter that bars any discriminatory action. Mr. Chairman, does the Minister understand that the structure she's now implementing will replace a structure which has already met the standards of the Charter, that she's replacing something that is already sure and has been built and tested by something completely arbitrary? She says that one of the guarantees is the Charter, but what kind of rights would an immigrant who is not yet here have if they're not able to be here to contest this under the Charter? And this is possible then to exclude certain categories like country of origin. And she's completely destroyed her own arguments at the beginning of her presentation today when she said that our problem is that we have to deal with all the applications in the order in which they were made. That she's saying that people can jump the queue. She's avowing something that cannot be admitted.
Is to help business stay in business, to make sure that the immigrants who are coming here get a chance to succeed in their jobs. That means matching their skills with our labor needs. That hasn't been done. If I could draw an analogy, it'd be like saying, okay, you're going to build Team Canada as a hockey team, and you'll take the first 25 people in line, right? That might seem fair because they lined up in that order. That's the way our immigration system works. But if you take the first 25, you might end up without a goalie. That's not going to meet the needs of the team. So what we're doing is trying to make sure that we do meet the needs of the team, but we would be processing people. For example, medical professionals at the front of the line out of some 400,000 a year. We're not going to be processing 400,000 medical professional applications, maybe 400, maybe 4,000. That leaves a lot of room for the other people who have applied to have their opportunity to come here as well. But we have to be fair to the people who are in the line. Otherwise, we're soon going to be facing 10-year wait times.
Thank you very much.
I must say that the analogy with the hockey team is the most absurd thing that I've ever heard here.
You have 7 minutes.
Thank you, Mr. Chair, and thank you, Minister, for coming here today. And I need to clarify with you, and I'm sure that you will understand that Ms. Chow's comments about groups not understanding this is not an accurate reflection of what many of us have heard in our meetings with groups, that indeed they do understand what is happening here and why it's happening. I'm sure we all have our own little horror story, if you will, of constituents, and I was elected the same time you were, Minister, and one of my first issues that I dealt with was a family reunification that still, maybe I'm failing, I don't know, but it still hasn't happened. So there's almost 4 years for one example of why the backlog isn't working, and I guess I congratulate you for putting this forward. I tend not to deal in the past, but I can't help but ask, and you probably have a better understanding, what created this backlog? What is there in the system? What requirements in the system created such a backlog that we're dealing with?
Well, there were a number of factors. A few years ago, there were 50,000 people in the backlog. When IRPA, the Immigration and Refugee Protection Act, was brought in 2002, in anticipation of that bill, we had a flood of applications. Unfortunately, the bill, as it was written, requires us to deal with every single application, and some people put in more than one. But so even if we have accepted an individual on the first application, if they've got 2 or 3 others in other streams or under related addresses or other names or whatever, we still have to go through and do the paperwork on each and every one. We have no control over the intake, the number of applications we receive. So it'd be like saying if you had a policy to return every telephone call that you receive, right? But you can do it only in the sequence in which you receive them. If you received a call from, say, from somebody who called you 5 times, you would have to call them back 5 times. If you had a call from a family member on an urgent matter, wouldn't matter. You would have to call them back in the order in which they were received. And so the system as it stands is totally inflexible. Not only does it not respond to our labor market needs, but frankly, it isn't fair because it makes people wait for way too long to find out even if they're eligible to come. The really good ones have a tendency to go elsewhere where they feel more welcomed.
Thank you. You referred to Advantage Canada, and I think this is something that we need to emphasize, is this is part of a plan that was put forward in 2006. I, as you know, come from Alberta, and we have a tremendous labor shortage. in our part of the world. As I understand, Ontario still has a labor shortage as well. How is this plan going to fix that problem for my province and yours?
Well, two ways. Number one is, and we're doing things we're not looking at these changes in isolation. We have a total vision for immigration. Because of the huge backlog and the impact that it's having, we're having to develop a number of workarounds to meet the needs of industry, to meet our other obligations. So one of the things we've done is expanded the temporary foreign worker program rather considerably. We welcomed some 130,000 temporary foreign workers last year. We're recruiting foreign students because they contribute $4 billion to our economy, and by getting credentialed here, they have the skills that we want to stay here. So we're going to be making it easier for both those groups to apply for permanent residence from within the country without having to go home and wait 6 years to think about coming back here. That's a new program called the Canadian Experience Class that we'll be launching next summer. So we're doing a number of things to try to meet the needs of industry. Because let's face it, with foreign students, they've got Canadian credentials. Why send them away? Let's keep them here. You know, they go to school, they get to know the town, they meet someone, fall in love, want to settle. Let's keep that talent here. And meanwhile, let's keep whittling down the backlog. Let's improve our processes. Once we get through the oldest of the files, each application on average will take less time. We'll be able to accelerate it. With more people on the job doing it better and faster, we will eventually be able to process all applications faster and get everyone here in a timely and internationally competitive way.
So you think this will give us the flexibility we need to,
by
of
identifying,
course, as we heard before, reunite families. That has to be a priority, as well as filling this skilled labor gap that we've got.
And it will also be supplemented by our expansion of the provincial nominee programs, where we've been lifting the caps on the PNPs so that each region, like Alberta, can identify the specific people that they need, which may be quite different from the people that Nova Scotia or Ontario needs. Frankly, in my part of the world, we don't have the big oil sands activities that you have. But we do have other challenges. And so we're trying to make sure that the systems are flexible enough to meet all the needs across the country.
Good. Mr. Wallace.
Go ahead, Mr. Wallace.
Thank you. I'll just be very quick. Be very quick, Mr. Chair. Thank you, Minister, for coming, and I appreciate you coming to Burlington last week and explaining to our constituents of Burlington what changes you're proposing. We've heard earlier through some of the questioning that some people are assuming, or some critics of the approach, is that we could just throw money at the immigration system. Maybe you could highlight for me, why these are unrealistic in terms of the assumptions that they're making about throwing money toward the problem, and why this approach is simply just not really feasible at this time.
Okay, well, there are a couple of parts to that answer. Number one is that if we just throw money at it, we're throwing it into a big dark hole, because the more we're dealing with a fundamentally broken system. We could actually double the size of the department by spending billions of dollars, and it would still take 4 years to chew up the backlog, assuming that there was no increase in it, assuming that the number of applications we received each year matched the total that we process. But with the rules that we're given to work with right now, if we were to speed that up, we would be attracting more applications. So then we'd have to put more money into it, which would generate more applications, more money. It would become a vicious, just a relentless spiral. And it's already out of control. We don't need that. That's why we have to change the system itself. It's the difference. You've just got to do it better. You've got to do it smarter. We need the flexibility because, quite frankly, the Immigration and Refugee Protection Act of 2002 was designed to protect the domestic labor market. And we need to give it the flexibility so that it can respond to changing Canadian conditions, changing world conditions as they change, and it needs to have a shelf life of more than 3 to 5 years, which this has proven it has, the existing one.
Okay, thank you. Thank you.
Okay, thank you very much. We'll now move into a 5-minute round. We'll start with Mr. Turner, 5 minutes.
Thank you very much, Minister. I have 3 quick questions for you. Why are you and the government blocking the Immigration Committee from having a look at this particular issue? This is the Finance Committee. I'm certainly not an expert in immigration. Why is this happening?
We're not. In fact, it was our members here that suggested, we voted unanimously to support your motion, this committee's motion, that the Citizenship and Immigration Committee review this and study the subject. And as well, we're quite prepared to discuss it in that venue. We've supported that every step of the way.
Okay. With these proposed changes, the Conservative government seems to be asking Canadians to give you, the minister, sweeping new powers. But you have, it seems to us, many people, tried to bury these provisions in Bill C-50. I think as my colleague Mr. McCallum showed, you actually misled the House on the number of immigrants. And the chair of the Refugee and Immigration Board actually resigned after you brought in increased ministerial discretion. So my simple question is, how can Canadians trust you with such sweeping powers when it seems you backdoored a number of things so far?
Well, with all due respect, we brought in this legislation. It was tabled in the House of Commons. It has been debated there live on national television with transcripts for any and all who want it. It's being debated here today. We've agreed to have it discussed at Citizenship and Immigration Committee. We're encouraging that. We've been engaged in debate across the country with literally hundreds of groups, and to make sure that they're aware of it. We're quite prepared to discuss it. But the key point here...
Why didn't it come in as a separate bill, Minister?
Because, number one, as I explained in my opening remarks, immigration is going to provide all of our net labor growth in this country by 2012.
I heard that, but why not as a separate bill?
Without labor, business will not be able to stay in business, and our budget is our economic blueprint for the country.
I heard
it's
that.
Very
I just
logical.
wondered if you could answer why it wasn't brought in as a separate bill.
Well, for two things. Number one, it's logical to include it in the budget. We said we'd do that in Budget 2006. We announced we'd do it. We did what we said we'd do. Number two, if you think back to some other really good legislation that we've brought before the House, it's been allowed to languish over a course of 2 years. We can't afford to wait that long. If we do, we're going to be inflicting 10-year wait times on immigrants. And I can't find any justification to do that and to give them false hope of coming here when that's really
obviously
what would
doesn't answer the question. But my third question is, and I'm asking this on behalf of some people who asked me to ask you. They live in Norfolk County, and they're pretty upset that a couple of nights ago you were a no-show at Delhi, and they asked me to ask you why you didn't go there.
I'm sorry, that has nothing to do with what's discussed here today. I thought we were here to address C-50. Well, I didn't realize that my riding activities were part of the debate of C-50.
You are the minister. Can you answer that question?
The minister has answered that question. Do you have another one, Mr. Attorney? Go ahead, answer another one.
Can you give an explanation as to why you weren't at that particular meeting?
Yeah.
The point of order.
She can answer the question, or she can not answer.
Sorry.
She's
I'm
a
sorry,
big
Mr.
girl.
Turner, your time is gone. Monsieur Blanchard, the time is yours. Go ahead.
She didn't answer the question.
Thank you, Mr. Chairman. I would like to carry on in the same vein as my colleague. He showed you some very eloquent figures. And I have some other figures here, too, that I'd like to share with you.
I have something to say, do it outside, but go ahead, Mr.
I'll carry on in the same vein as my colleague. Mr. Chairman, I have some figures here. At the end of 2020, 3,495 people were waiting, which means 3,000 more than the previous year. And the treatment time for files has gone from 11.7 months to 14.3 months. And that, Madam Minister, has consequences for quite a few people. On the other hand, as you know, Quebec has to take care of the social services for these people. And when you go from 11 months to 14 months, this has a direct impact on the Quebec budget and provincial budgets. So my first question for you, and I'll have 3 questions and not much time. In this bill, are you ready to compensate the provinces for the wait time due to the lack of appointed commissioners? I think this is important. It's not because Ottawa is slow that provinces in Quebec have to pay for this. That's my first question. And are you also ready to compensate the families? Because for family reunification, if time drags on and families have added expenses, and then regarding national security, there are people waiting there with criminal records. So I don't know how Mr. Stockwell Day of National Security looks at this, but it is a worrisome matter because the longer we wait, the more there's a possibility of terrorist or criminal infiltration during that time. And then also there are experts who deem that the lack of appointed commissioners is due to people who do not share your ideology regarding the government. So how do you answer to those experts who say that people don't share your ideology?
What we're trying to do here is bring some common sense and some good management techniques to the backlog. We're trying to make sure that we get families together faster than they have been. The wait times for those people have been growing. We're also trying to get skilled workers here sooner and get the ones here that are needed for the jobs. It's a better fit for everybody. We do have arrangements with the provinces for compensation in terms of refugees, but it's a factor that goes into the annual general transfer. So recognition of increases or decreases in the number of refugees going to each province is already accounted for there. When you talk about the families, that's very, very important. Refugees are, as I mentioned earlier, a separate case from the regular immigration stream. Yes, we have some challenges. Yes, we have to make sure that we uphold our #1 responsibility as a department, which is to ensure the safety and the security and the health of those who are already in this country. And to do that, we have to do extensive security checks. We have to make sure that people who are allowed to come here, pass the criminality tests, because we don't want bad guys coming in. We want good guys coming. And we, as a country, as a government, we believe every government's first job is to defend its people. And that's what we're doing when we stop people from coming in who we determine have criminal records.
OK, puis l'allégation des...
The experts allege that you're slowing down the appointment of commissioners because you're trying to find people who will have the same ideology as a Conservative Party. Is this entirely false? You're already making signs and negative signs. So does that mean that if you appoint commissioners who are very libertarian and want to bring everybody, this would be contrary to your ideology, because now you said that you have a test and you want to make sure that these people are competent. Of course, not only Conservatives will be appointed, but at least will the tests also propose the Conservative Party's slant on immigration?
Immigration and Refugee Board, who are going to be competent. And I think that competence transcends party lines. I actually happen to believe that all parties can have competent people. And we have a test that we administer. We have a rigorous interview process. We have a selection board with people who are independent, who choose, who can advance. And it's a very, very rigorous process. And as I say, only 30 to 40% make it through. That means it's a high standard. And we do that to make sure that we're getting qualified people, so that people who can recognize when somebody's trying to abuse our system. And unfortunately, we do have a lot of people claim refugee status who are trying to abuse what is a really good program.
Okay. Thank you, Mr. Demastro.
Thank you, Mr. Chair. Madam Minister, you would...
Could I just add one thing? And I would point out that we have, of our nominations, over 50 of them, I believe, have been reappointments.
Thank you. Mr. DeMaster.
Thank you, Mr. Chair. Madam Minister, first, an apology. You would think that someone that opened their questioning by saying that they don't understand a lot about immigration would have stuck to questioning so that they might learn something about immigration rather than petty partisanship. Unfortunately, we do see that at this committee from time to time from that individual. In terms of history, in Canada, we are all relative newcomers to this country, and we built. So we understand the value of immigration. We understand the very real contributions that immigrants have made to the Canadian society. With that in mind, could you please share with us some more the details about how the proposed legislative changes in Part 6 are crucial to the ongoing future success of Canada's economy and immigrants to Canada?
Thank you. What a very good question.
Thank you.
As I said, by 2012, all the forecasts are that our net labor growth, all of it, will have to come from immigration, because as a country, we have an aging population, early retirement, people having fewer babies much later in life. So to keep our economy going, we need people. Businesses can't stay in business without the right people, but they have to be the right people in the right place at the right time. And right now, we're not getting those people through our existing permanent resident program, which is why we've had to do workarounds. But workarounds aren't sustainable in the long term. The system is fundamentally flawed. That needs to be fixed. The previous government talked about doing it. The problem is they never did. Under their watch, the backlog ballooned from 50,000 to over 800,000. And because there are systemic flaws, we can't just throw money at it, because that won't make the systemic flaws go away. We have to fix the system, the structure of it, which is what these amendments will do, as well put more resources to it, which is what we're doing, $109 million. But we also have to get smarter about how we do things, deploy more current technology, review and revise all of our processes so that we're doing things as efficiently and as effectively as we can to get more people here faster.
Mr. Chair, I'd like to share the balance of my time with Mr. Dexter.
Well, thank you, Mr. Chair. Just through you to the Minister, one of the parts of all of this is and it's been alluded to a few times, there's millions of dollars involved here in both this year and next year's budget and subsequent budgets, up to $37 million a year in terms of increased funding for trying to deal with a backlog, trying to address the issues which you've outlined here today. And one of the, I think, important parts of that is understanding the changes to the IRPA in Part 6 of Bill C-50 and exactly how those funding increases will assist you, but assist, and probably more particularly assist those working within the ministry to be able to do some of the work that you've outlined in the bill.
Well, for one thing, we'll be able to hire more visa officers overseas. That's a good thing. That's just putting sheer more volume, which is what many here have suggested we do. But it will also help us fund systems and allow centralizing of processing, because quite frankly, it costs us less to have someone in this country do the processing than in many places offshore. Modernize our systems. Some of our computer systems are ancient by any standard. And we have members of Parliament who are younger than some of our computer systems. So we need to take a giant leap forward in the 1990s in some cases. We're also going to be coding files, and that so that we can identify newcomers or applicants by their occupation, by the province of destination, so that we can share that with the provincial nominee programs. We're going to be doing a letter campaign to the oldest files, asking them if they'd like a refund, or if they, because they've decided to get on with their lives, or whether they still want to come here. Hopefully that'll withdraw some people from the backlog as well. So we're going to take a number of measures.
One really quick question, and that is, do you think that part of the reason that the Liberals in the former government introduced the almost $1,000 landing fee was in a way, in part, to prevent and stop the backlog from where it was?
Well, to be honest, I hadn't thought of that, but frankly, I just see that as the wrong kind of barrier, because it discriminates on against large families. And it doesn't recognize that we need a wide range of people coming to this country, and it doesn't help serve anybody faster.
Thank you.
Thank you very much. I want to honor the minister's time. We have one more question, Mr. McKay. I'll give him a couple of minutes.
Minister, this request on in C-50 is all about expanding your discretionary power. Yet under the IRB and under your watch, you have increased the refugee backlog by something in the order of about 300%, for about 20,000 up to 60,000. You've reduced the a number of judges available from about, well, at one point it was a backlog of only about 10 appointments. Now it's up to around 60 appointments. And to no one's great surprise, therefore, the processing times have gone up exponentially. And then in a blatant political move, you substituted your own political discretion for the advice of the advisory panel, and a week later the advisory panel quit en masse. And then you come to this committee and you say, but trust me, I want to have, I want to have more discretionary power. So my question is quite simple, Minister. Given your track record with respect to the IRB, where you reduced appointments, increased wait times, and in effect substituted your own political decisions for those of the advisory panel, why should we trust you with respect to this increased discretion?
Well, I think one of the key things is because when we present figures, we present them in the entire context to give people the background. To say that there was a 100% increase in something, that number may have gone from 1 to 2, or maybe from 100 to 200,000. And on a scale of magnitude, that's a big difference. When we look at the IRB backlog and how it's grown, there are a number of factors that have caused that. When we took over, there were approximately 100 vacancies imminent. They weren't open on that day that we took over, but they were imminent within the next few months, and nothing had been done to fill them. So we looked at how the appointments were. We said this isn't good enough. We improved the quality and the standards. We've made over 100 appointments. We have several more in the works. We've also expanded the total number of positions that we're trying to fill. And another reason for the backlog growing is that we've seen a significant increase in the number of applications. Remember I said before, we can't control the number of applications that come in. Well, if we more come in than we can process, then yes, the backlog is going to grow significantly. But there are a couple of reasons for that. There have been particular responses to activities by our neighbors to the south that have caused dramatic increases in the number of applications we receive. And no, we can't process them all, but we are well on our way to filling a much larger complement of IRB positions with very competent people.
That was very true. And we want to close this part of the session. We want to thank the Minister for her time and coming to the committee and answering the questions. We will have the department to stay behind, and we have another hour if there's further questions from the committee. So I want to thank you on behalf of the committee, Madam Minister, for spending the time with us.
Thank you.
Thank you. We'll now suspend for just a short time, maybe a minute or two, as the Minister leaves and we have the officials coming forward. I want to call the meeting back to order. We have with us Andrea Leon and as well Jamie McNamee from the department. We have them both here. We will continue with our questioning. We have, first of all, I think next in line would be the Conservative Party. Do we have any questions? Do we have any questions from the Conservative Party? If not, we'll move to the Liberal Party. Mr. McCallum, the floor is yours, 5 minutes.
Thank you. I guess my first question is whether you would define a foreign student as a new Canadian, a foreign student studying in Canada.
I guess, Mr. McCallum, that would depend on the context in which they were arriving. I think as the Minister described in her remarks, the government is moving to implement a program that will facilitate the movement of foreign students and certain temporary foreign workers into permanent residency in a much faster manner. That program will come into place sometime later this year, and as I say, will greatly expedite that process of permanent residency. So it really depends on where on the continuum this person falls.
But that hasn't happened yet, and not all of them will become landed immigrants. So how can you refer to those students and temporary workers as new Canadians?
Well, it will be in effect shortly.
I beg your pardon?
I said the system or the new program will be in effect very soon.
No, but even if there is a new program, they won't be new Canadians until they've applied and been accepted. Is that not true?
That's correct.
So then you can't say there's 400,000 plus new Canadians admitted into the country in a given year.
I think what the Minister was referring to in her press release was the fact that in the year 2007, there were a record number of people that entered Canada under a variety of different classes. Yes, there was a large increase in temporary foreign workers year over year, reflecting a fairly large economic growth. And
I wouldn't disagree that a large number of people entered Canada, but my point is they were not new Canadians. 400,000 new Canadians is inaccurate, is it not?
I'm not going to comment on the accuracy or inaccuracy of that.
Departmental number.
Okay, I'll move on.
So who's going to comment on it?
Motion to bring the Minister back to comment on her department.
I think this question was there. I believe it's you're talking definition is a student, and I'm just trying to interpret what I've heard here. And what I heard was that the definition of whether you call a student a Canadian or in Canada or not was the issue. But go ahead.
Well, maybe I'll move on to a different subject.
You can make that issue in another forum than this one, but carry on.
Hey, can I just respond to that, Mr. Chairman, in terms of what you said there? In terms of a Canadian, there is, of course, a separate process, as members know, leading to citizenship. So there are various points on the continuum, beginning from a temporary foreign worker or a student that can allow people to gain permanent residency, and then thereafter, should they meet application processes to, in fact, become a Canadian.
Right. But I think you would agree that upon point of entry, a foreign student is not a new Canadian.
Not on point of entry, no.
Okay, good. Because she said there were 400,000 new Canadians entered. So that solves that one. Let me now go on.
No.
Well, you can ask that question, Guy. I'll change the subject. The Minister spoke a lot about using her new ministerial instruction powers to choose certain classes of immigrants based on their skills. So my question is whether these clauses also give the Minister the authority to pick which applications do or don't get considered in the family class. For example, could a future minister, not would, but could a future minister issue a ministerial instruction to not process grandparent or parent reunification applications, for example?
It would not give the Minister that authority insofar it was inconsistent with the overall objectives of the Immigration and Refugee Protection Act, which, as one, require the government to ensure that the immigration program supports economic competitiveness, family reunification, and also provides protection to those in need. I think the Minister also talked about the potential to use the instruction process as a way to attach priority processing to certain groups, as indeed is our intention with respect to those occupations.
So it would be possible then to attach a high priority to occupations A, B, and C, and a low priority to family reunification.
No, because she must, and we must, make sure that there is a balance across those three objectives of economic competitiveness, family reunification, and protection to those in need. It is not one at the expense of the other.
Is she bound by certain percentages of family versus economic?
No, the statute does not specify certain percentages, but she is required to abide by that objective that's laid out in the Immigration and Refugee Protection Act.
All right, but that's a general objective. She could claim that she was still pursuing a policy of balance and put a higher priority on economic immigrants to certain trades and implicitly or explicitly a lower priority on family reunification. Is that not right?
Well, I think it's also it's useful to point out that at the moment we have established some priority processing for certain family classes, and indeed the processing of those tend to proceed on a fairly expeditious basis. What we're faced with is a backlog of some 800,000 in the federal skilled worker category, where the processing times, as the minister described, can be up to 6 years. So you can almost look at it as a way to ensure that the economic side is gaining the same sort of priority that currently the family class is receiving. That is one way of looking at these amendments.
So,
Thank you very much. Your time is gone. Mr. Wallace, you have 5 minutes.
Thank you, Mr. Chair, and thank you for joining us today. I just wasn't ready when they came to us before. Just a few questions that I have for you today, and one of the areas that I want to start with is there any changes that you would recommend from a staff perspective on anything that's in Bill C-50, since that's what we're actually here to discuss, that need to be any minor changes at all that would need to be able to implement what we're trying to accomplish, or is what's in the implementation bill satisfactory to staff's requirements to make that happen?
From our perspective, it will provide us with that additional flexibility that we require in order to bring the Canadian system up to the level of some of our competitors, those other immigrant-receiving countries such as Australia and New Zealand. We think that it will provide, A, the sort of budgetary investments that will be helpful, and B, correct some of those structural deficiencies that currently exist in the legislation.
Okay. Let's take a sort of a guess that this actually passes, and we assume that we get this through the House of Commons and so on through the Senate. Well, what's the time frame in terms of implementation, in terms of making these changes that are required?
The minister has talked as well about the instruction process requiring a fairly broad consultation with interested stakeholders. Once the legislation is passed, assuming it is passed, then we will need to engage in that consultative process with those stakeholders, and I would include among them the provinces, the territories, business groups, labor groups, and other interested parties who are probably very well placed to give us a sense as to those occupations that are high priority for Canada.
So I have met recently, and I'm just using this as an example, with the laboratory medical professionals who work in the labs, basically at hospitals, doing all the medical tests that your doctor performs, your nurse performs, and then gives the results to the doctor. About 20% of their staffing comes from immigrants at the point. They have to meet the qualifications, of course, and everything else. But they are desperate for people, and one of the solutions, only one part of the solution, is maybe they'd be able to attract more laboratory professionals from overseas. What, if as their MP, what would you recommend me tell them in terms of a time frame? Are they looking at this time next year, 2 years from now? What do you think, based on your experience, the real time frame to actually seeing some tangible results for Canada?
It's difficult to say in terms of the instruction process. Clearly, our objective is to finalize the instructions as quickly as possible, ideally by early fall, so that we can begin that process. So that's sort of a rough time frame, but we do still need to map out exactly what the consultation process will look like and what sort of steps that will involve.
Do I have another minute? Now, since I have you here, and I'm not on the Citizen and Immigration Committee, I thought I'd ask you another question. In your field, though, we launched the Foreign Credentials Referral Office. Could you just give us an update of, it's only been a year, well, not even quite a year yet, I think, since this was launched. Could you give us a progress report on how that's developing and where you see that headed? Sure.
The minister, in fact, just spoke at a conference on the issue last week in Calgary. You're quite right. The program has been in effect for just shy of a year. We've now set up 320 points of service across Canada to provide information with respect to the labour market conditions in Canada and information in order to connect prospective immigrants with professional associations in Canada that will allow them to become aware of what the rules, what the procedures are, so that they can start the process before they actually come to Canada. We've also set up a pilot project involving some of our high-volume missions, such as Manila, Delhi, and India. Or sorry, I can't remember what the third one was. Sorry? To give advice abroad, so that again people can access this information. There's a 1-800. There's a call number. We've got a website that receives an awful lot of hits that gives that kind of general information.
So the process has started.
Yes.
Okay. Thank you.
Thank you very much. We'll move now to Monsieur Maclair. You have 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. First, let me say that our colleague, Mr. Paget, the clerk, has a document that has a proposition which is in a straight line with what we discussed last week, that as soon as possible we meet with the Committee of Citizenship and Immigration, and I think there's a slight typo in the French version. The English version is complete, and simply because this is a motion that deals with today's subject, we don't need a 48-hour notice, and we need unanimous consent from our Commission to do joint work, and that this would be with the two chairs taking turns, and this would be done right after this motion is adopted, and this is what we're moving, and we hope that all of our colleagues will collaborate with us.
Perhaps to deal with, but I think we're still in the question and answer period, so let's ask the questions. If not, then we'll deal with that. We'll leave time at the end of the meeting to deal with that.
Bien. Alors, je vais poser très brièvement une question aux deux.
So I have one or two very brief questions to the persons whom I thank for being with us today. Just now, the Minister spoke of classes. And as far as I'm concerned, this regulation is a strictly provincial mandate. So, for example, if a physician was trained in the rump Soviet Union, for example, and all he needs to have an internship in a hospital. So in the bill, is there anything that you change in the fate of that physician? I do not see anything at all.
That we were just talking about for foreign credential recognition is going to be an important consideration as we proceed to develop our instructions. And it is for that reason that we are going to need to discuss very closely with the provinces what they view as priority occupations. The issue of foreign credential recognition falls, as you know, under provincial jurisdiction, so we need to work with them to ensure that those priority occupations that we identify, that those people that fall within that category can actually practice medicine or practice law once they come to Canada. So we recognize that that is going to be an important component of our consideration.
Mais, et je vous remercie pour votre réponse.
Thank you for your very complete answer. But if I understand you clearly, you are now telling us that not one extra cent has been provided for recognizing equivalent diplomas.
We haven't quite sorted out precisely how we're going to proceed on the consultation process. That we have talked to them about the foreign credential recognition issue. We have said that this process is going to need to proceed hand in glove. The minister referred to this in her remarks last week in Calgary as well. So once the formal consultative process is fully engaged, I suspect that that will be an issue that we will want to talk to the provinces about, and vice versa.
Okay, Ms. Chow.
Yep, quick question.
Very tight.
I see that there are ads that are being put out by your department. It doesn't really tell the whole truth, and it talks about the information will be published, etc. But it doesn't say that the Charter of Rights really wouldn't impact on cases that are outside Canada, and that the backlog really doesn't have a whole lot to do with the student visa, work permits. There's no backlog in any of those. So why would changing the shall to may and denying them the right for a visa, even if the applicants meet all criteria, what does that have to do with the backlog?
Well, thanks for the question, because I think those are two areas where there has been a lot of discussion in particular. I'll start with the charter issue in the first instance. Indeed, the charter does apply to everything that we do as officials. The charter binds Government of Canada officials in the execution of all government policy, be it in Canada or abroad. Okay. And that is likewise specified in Section 3 of the Immigration and Refugee Protection Act. So we are bound by the Charter. With respect to your second point on the shall versus may issue, what that particular provision does in the bill is it means that we, the government, are no longer required to process each and every application, and it is that requirement.
Including the student visa and the workers permit?
No, that's only on the permanent residency side. So it doesn't apply on the temporary
really,
side.
But because the wording of that change impacts on all visas.
It applies just for the permanent residents.
Can you clarify?
That's it. The time is gone. Mr. McKay, you have 5 minutes.
Thank you, Mr. Chairman. I learned something interesting today, and that is that Canada has a shortage of lawyers. I can't believe it. I'm having difficulties accepting that, Mr. Speaker. This is again the issue of an expansion of discretionary powers, where this minister has demonstrated somewhat less than candor with respect to other issues. Now, can you confirm that the refugee backlog is up from 20,000 to about 60,000? Is that true?
I think as we sit here, I think that the backlog is around 41,000.
No. And can you confirm that the appointments, outstanding appointments, have gone from about 10 to about 60? Yet vacancies on the board.
I have to apologize. I don't have the specific number here. I think it is.
But does that
under
sound right?
60.
And the board is about 150 people?
That's right.
So your complement or your staffing complement is about 60% of capacity. Is that fair?
I don't have the numbers, so I can't confirm those.
And can you tell me whether the effect of the change with respect to the advisory panel was that instead of the advisory panel essentially making the appointments, that effectively the minister trumps now the advisory panel? Is that a fair observation?
I don't know that I would necessarily say trump. I think what the process provides for is a final decision by the governor in council.
So that's essentially the minister. So it's trumped by any other word. So before the process, before this change of process, the minister was essentially obliged to take the advice of the advisory panel, and because it was, if you will, an arm's length appointment and a quasi-judicial. And now we've turned it into, or now the minister has turned it into a position whereby the minister says these will be the appointments. Is that fair?
That's generally the process. I must apologize. I'm not an expert on the IRB because I thought we were discussing C-50.
So over the course of this minister's watch, we've run up the refugee backlog by something in the order of 100% on your numbers, 200% on other people's numbers. We're down to about a 60% complement on the board, and she gets to decide who's on the board and who's not. Is that a fair summary?
I'm just sorry, I am just looking at some numbers here in terms of the backlog inventory. I mean, what I can say, and I don't know what the precise situation was in terms of IRB complement at various points in time, but the numbers have gone from 41,000 in 2003 to down to 27,000 in 2004, and then up a bit. So there seems to be an ebb and flow.
Of course, there's variation.
Exactly, and what I can't say is whether or not there were commensurate decreases in terms of the IRB complement at that time.
But the minister said, well, that's because we're getting rushes from third countries. But we have this third-party agreement that a lot of these refugee claimants, particularly from the United States, are turned right around. And so you don't have that system that existed previously, and still you're not adequately staffing the IRB, and you're running up the backlog. It therefore, and then you put a section into the bill and say, trust me, I want to have more discretion. Look what I did with the IRB. Didn't I do a good job? Well, by any statistical measurement, let alone political measurement, the minister has not done a good job. She's run up the numbers on the backlog, and she's down the numbers on the board. And so it makes it very difficult to say, well, trust me, I'll do a better job next time. Thank you.
I guess I can only comment as an official on the facts that are before us, and the facts are that we have a backlog at the moment of 925,000 people, a reality that is greatly constricting our ability to do our work.
To which you're applying $22 million.
The large component of that constitutes the federal skilled worker program. So what the government is pursuing is a strategy for resolving or helping to tackle that backlog, the existence of which impedes our ability to deal with the whole immigration system as a whole, because it is one system that deals with all the different categories. And you talked about the budgetary investments. The minister elaborated on what we intend to do with those monies, both in terms of letter writing campaigns to confirm the interest of people who are currently in the backlog, in terms of attaching additional resources to some of our high-volume missions, to undertake some administrative efficiency.
Sorry, your time's gone. It's a good try. I already told you that. Mr. Laforêt, order. Mr. Laforêt, the floor is yours. Mr. Wallace.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. We are witnessing something entirely new, and I would like to tell me about how you see this. By dint of introducing these criteria of employability and professional skill before the immigration process, is this entirely new?
Identifying particular priorities.
Dans les priorités, le fait d'introduire.
Within the priorities that you introduce, that you want to give priority to immigration according to their professional qualifications, is this entirely new? Or did this exist previously?
of other jurisdictions. In fact, Canada, I think, is one of the only major immigrant receiving countries that currently lacks the ability to go through some sort of occupational filter so as to ensure that we're matching skills with needs in the domestic market. So other countries such as Australia and New Zealand and the UK have similar sorts of systems that allow them to establish priorities based on labor market needs.
Donc, ce que vous dites, ici au Canada, oui, c'est...
So this is new in Canada, although it's not new elsewhere. Can a process of this importance, and that has been changed so radically, I think that within the department you must have already produced some notes or studies and prepared arguments to ensure that the minister can say that we need to change the system and give the minister new powers. I'm sure that you've looked into this.
If you go to the CIC website, you'll find a good deal of that information up there, and some of the rationale for the amendments, for the budgetary investments, and indeed the kinds of things that the minister was talking about this afternoon form the basis of the analysis that we had done and appear on our website.
Quand vous faites, je suis convaincu.
I am convinced that whenever an official speaks to a minister, there's a certain line of reasoning for, and a line of reasoning that also shows the downside. Will the minister decide, after having heard both sides, for and against? And what were the downsides that you mentioned to the minister before pushing this process to the extent that where it is now?
To get into breaching confidence in terms of advice to ministers, one of the factors that we looked at very seriously were the consequences of doing nothing over the next few years, and with the prospect of having the backlog grow from its current size, which is already fairly daunting, up to over 1.5 million potential applications, with wait times associated with them of some 10 years, that was a fairly motivating factor in terms of identifying a solution that would help the government begin to tackle the backlog and make the system more competitive with some of the other countries that are currently having more success in terms of newcomers.
Est-ce que vous avez proposé d'autres scénarios aussi?
Did you propose any other options to the minister to get to the same result? Were there other hypotheses, other ways of going about things to get results that are similar? Or at least...
And as I said, I'm not going to disclose ministerial confidences in this forum, but certainly I think if you look at some of the academic papers, or if you look at what some other countries have done, they may or may not necessarily be portable to the Canadian scene and respond to some of the Canadian demands. We also have a fairly unique system insofar as the constitutional responsibility for immigration is shared jointly with the provinces, so that also weighs in terms of the options that we pursue and that we look at.
Okay, thank you very much. We'll now move to Mr. Dykstra. The floor is yours, 5 minutes.
Through you, Chair. I've had a chance to look through Bill C-50. I've had a chance to look through all the materials that the ministry's provided, and I've heard Ms. Chow say it. I've heard members of the Bloc say it. I've heard members of the Liberal Party say it. I've heard, obviously, not just Ms. Chow, but other members of the NDP Party say. But this is this part of the bill is built on conservative ideology. I wondered if you could tell me where in this document you, as ministry officials, put those two words in this document, because I can't find them.
I can only really speak to what the intent is from an official's perspective. Our primary concern is ensuring that the system operates as efficiently and responsibly as it can. Our view is that the sort of amendments that have been put forward, most notably the fact that we no longer would be required to process all applications, will give us that sort of agility to make the system more modern and more responsive to deal with labor market pressures, but also ensuring and applying the human capital model that we have over the longer term, the sort of skill sets that Canada will need in the coming years. So I can only comment on what.
Sure. No, thank you. That's very helpful. So your position and the advice that you, and I don't want to get into the advice because I realize it's confidential, but the way that you have put this forward in terms of moving this part of the bill has been to do, I guess, more than what Mr. McKay is suggesting, that we do nothing. This actually, these changes, these amendments, from your perspective, from a ministry perspective, are to improve the way that we deal with the issue of immigration.
That's correct. We're operating within a framework as well that you're familiar with in terms of the overall levels that we need to attain each year, and that is set out in the annual plan. So everything we do in terms of the exercise of these instructions must be seen in the context of those overall levels. That ultimately is going to be what guides us as we pursue this, and we think that these amendments will allow us to respond much more flexibly than what we're able to today.
The other, I guess the third question I have and the final question is in respect to the comments, again, being made that, you know, that somehow that this gives the minister some carte blanche ability to allow to be the self-professed chooser of who comes into this country and who does not. Can you clarify whether that the fact that has been stated by the opposition parties and also by some members of interest groups that have moved in on this in terms of debate, and it's been a healthy debate, no question about it. Can you explain how that is or is not the case with respect to the amendments in this legislation, that it does not give, or perhaps it does, let us know, does it or does it not give the minister sweeping powers to let anyone into the country that they so wish?
It does not. It does not give the minister that sort of unfettered discretion at all. It is framed by a number of important realities that I'll just tick through quickly, if I may. One of them is the annual the levels exercise. So whatever we do on the instructions must be consistent with the overall levels that the Government of Canada will have determined, and those are published every year and tabled in the House of Commons. It also must be consistent with those objectives in the Immigration and Refugee Protection Act that I talked about earlier, so economic competitiveness, family reunification, and providing protection to those in need. Very importantly, it must be consistent with the Charter of Rights and Freedoms. Everything we do must be consistent with the Charter of Rights and Freedoms, and that explicitly prohibits any form of discrimination. The documents, or the instructions rather, will be the subject of consultations with provinces, with territories, with industry groups, with labor groups and other stakeholders to make sure that we've got it right when we do go through that process of identifying what sort of priorities we want to accord among certain occupational groups. And finally, on the transparency side, the minister has committed to having the document go through Cabinet, A, to have it published in the Canada Gazette, and B, to have it published on the CIC website and included in the annual levels document. The point that the minister made in her remarks, I think, is also worth underscoring, and that is an allegation that the minister would be able to override a decision of a visa officer, and that is incorrect. Once the decision is taken with respect to a priority, it is the visa officer that must go through the process and examine it, determine whether or not the point systems have been made, and all those other standard processes involved.
And thank you very much. We'll now move to Ms. Hall-Finley.
Thanks, guys. I am, sir.
She's almost official. Go ahead.
Almost official.
What do you say that the chairman's biased?
Just hush, okay? I'm about to ask my question. Ms. Lyon, my understanding is that with these changed rules, if you are applying on the basis of humanitarian and compassionate grounds, but you are living abroad, you will no longer be eligible to apply to come to Canada. In the words of one department official, this is a tool to protect the integrity of the system. Is that your understanding of?
It is not. It is not a blanket prohibition, that particular clause that you're citing. When considering that particular amendment and H&C, humanitarian and compassionate applications, we did distinguish between those made in Canada and those abroad. The reason that the legislation expressly prohibits the instructions applying to those in Canada is because there are some unique circumstances that may arise with respect to those people that are affected by it. They've established here, they have children here, occupations, etc.
Yeah, but the concern is a prohibition on the ones outside of the country.
And it's not a prohibition. What the legislation does is give visa officers the discretion to deny that in circumstances. So it's not an outright prohibition, but it could apply in those circumstances where it might otherwise be used as a way to circumvent the priority occupations list. So, for example, if somebody applies as profession X is not on the priorities list, and then they subsequently seek H&C application status abroad, the officer would have that discretion.
But is there any requirement that the discretion that is to be allowed would in fact be used on that basis as opposed to for any other reasons? And I ask that because the language of it being a tool to protect the integrity of the system does raise eyebrows here, and I think raises a significant number of eyebrows elsewhere in the country, and I would suggest for good reason. And so, again, there is concern about discretion. Is your understanding that the discretion would have to be used in a case as though you just described, where somebody has applied only after not being accepted under another basis?
Certainly the intention of that particular provision is not to deny H&C access to those deserving of H&C. Those people deserving of it will continue to have their applications heard in the normal manner and normal fashion.
But it's not clear that that is the intention. Is there anything in the provisions that actually clarifies that rather than just a blanket discretion to somehow protect the integrity, there are actually parameters, there are details in the provisions that specify that intention is not, that the intention, if I turn it around, is in fact to continue to accept people who are applying from abroad on legitimately humanitarian and compassionate grounds?
I can't comment in terms of specific legal drafting. I can say certainly that the advice from our counsel was that this was an appropriate way to draft that language so as to accord the discretion to the visa officer and so as not to impose an outright prohibition.
And again, my point is the concern that we have is exactly with the discretion without anything else to suggest that this discretion be used in a way that would still allow people to apply who really do need to apply on humanitarian compassionate grounds. Our concern is that this can be used with open discretion to deny people that some bureaucrat or some political person might actually feel was arguably cheating or otherwise the system, and that discretion might be used inappropriately.
What we have in the context of the amendments are the overall parameters in terms of the authorities that can be exercised. The instructions, once they're issued, are going to elaborate on a number of things. One will be those priority occupations, the numbers permitted, the disposition of various applications, issues such as H&C applications, so that people abroad will have a clear sense as to what the rules of the game are going to be.
Okay. And thank you very much, Monsieur Godet. If you have a couple of questions.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Just one brief question. You said that 900,000 people are waiting. What I don't understand is that you had to wait for 900,000 people backlog before changing the legislation. Is it because there is not enough officials? Is this a bureaucratic problem? 900,000 in the wait list, that's a real problem. And if I had a company and I had 900,000 people waiting, it wouldn't be very great performance. So you had to wait till 900,000 people stand in line before doing anything about it. Where's the problem? Was it a bureaucratic problem? I'd like to have an answer. Is it because the system is bad or the legislation is bad? And do you think that this new legislation is going to make things go faster? Do you think that we'll have a shorter line? I think that with the bureaucracy we have, people tell us that civil servants are just pencil pushers, and they just sit there and do nothing but push pencils. So why did it have to rise to 900,000? I just want a simple answer.
I don't know that I would necessarily agree with your depiction of officials' work on it, but it is an issue that we need to address because, as I mentioned earlier, and I think as the Minister pointed out, it is having a serious impact in terms of the efficiency and the effectiveness of the overall system. One of the primary problems with the system as it exists right now is the obligation to process all applications. Canada is a very attractive and popular place, and every year we receive far more applicants than we can reasonably absorb. And by absorb, I mean have the capacity to ensure appropriate integration. So we're obliged to establish certain limits or targets in terms of the number of people we accept each year. I agree with you that the problem has been long-standing and growing, but from an official's perspective, we believe that the investments and the amendments that have been proposed in C-50 will help us grapple with the problem and gradually bring down the backlog so as to ensure that we're as competitive as some of our other immigrant-receiving counterparts.
Okay.
Okay, merci.
Okay. Thank you very much. We want to leave time. There was indication. You have one more question?
Yeah,
okay, very tight.
Yeah,
Go ahead.
It's a finance-related question. I used to sit on the immigration committee, and was one of my favorite questions was how much does it cost to bring in an immigrant or on a yearly basis? I know that it's a complicated calculation, but we can never get an answer. Now, if the goal, because we're still not clear if the goal is to bring in less people or more people, so I'm not even sure if, because last year we didn't, the government didn't respect its commitment because they wanted to bring in, I believe, between 240 and 260,000 people, and only 236 or 220 were brought in. So with the amount of money that is now being allocated, do you want to be bringing in more immigrants or less?
I can't
answer on that.
And with that, then let me do. With that, how much money would it cost? Okay. Is it the 77? Is it the 72 million, 700 million, 22 million, or 109 million?
I don't have statistics with respect to a per immigrant cost. I can address the issue with respect to what our objective is, and our objective is, as framed in those levels, exercises. And that is to maximize the number. The Minister talked about the sort of acute demographic challenges that we're facing as a nation. We're not unique in that respect, but we do have an aging population. We do have
but to bring in the goal of 250,000,
we do
no,
have
but
an
it's a question. I'm not getting
to ensure that by 2012 we have enough numbers to respond to the labor force, because immigrants will be the sole source of our labor force growth.
That's it. Okay. Thank you very much for the department for coming forward. I appreciate you being here and the time that was spent, and we'll dismiss that part of the motion of the meeting. But we would now ask that Mr. Mulclair, you put forward your motion.
Non, non, je veux parler avec les invités, Monsieur le Président.
To speak for our guests, Mr. Chairman. I want to speak to our guests. The motion can wait. I would like to take advantage of the officials being here. My motion can wait for another day. And I'd like to... That's it. That can wait for another day. I have a question for the officials.
We will allow Mr. Pichetti then to continue because we do have a few more minutes. Go ahead if you'd like to continue on.
The question is very simple. To bring in 200, to meet the goal of 240 to 260, so let's say 250,000 immigrants, what is it going to cost?
I'm sorry, I don't have that number.
But how can you not have it? Somebody's got to have it. I mean, the Department of Finance doesn't have it, the Department of Immigration doesn't have it, the Minister of Finance doesn't have it, the Minister of Immigration doesn't have it. So who's supposed to have it?
Well, I can tell you that part of the factors involved in this are we have 90 missions across the globe in dealing with these sorts of issues. We have about 1,500 officers that are dealing with them. Processing times are going to vary from mission to mission. There's costs associated with processing times. There's going to be complexities associated with processing individual
I don't mean to interrupt.
applicants.
I don't mean to interrupt, but our time is limited.
Because some people may have security concerns that cause further
I understand all that.
So there's certainly a range of factors that one would have to take into account. So I regret I don't have any more specific numbers for you.
I understand.
Go ahead.
I understand all this. The question, it's not the first time we bring in immigrants, but if we're going to change the way we do things, it's going to require money. So how much money is it going to require to actually bring in the 250,000 immigrants? You don't have to give me to the dollar figure, but round it to the nearest billion if you'd like. But at least you should be able to come within a couple of $billion bucks. You can get back to me if you don't want to commit to it. You can get back to us.
The levels exercise that we have and had have been founded on a number of factors. One would be the overall departmental budget, which is, I think it's $1.4 billion or something in around that ballpark. So that's what allows us, and that is one of the myriad of factors that allows us to establish what those levels are. Provinces have concerns. They have certain financial obligations in terms of supporting.
Do we need to increase that?
Time is
Do we
gone.
need to increase to 1.4?
Okay, fair enough. Mr. DeMastro, you'll be the last questioner, and then I've got an announcement to make for the committee, and then we'll call it. Go ahead.
Thank you, Mr. Chair. Madam Leon, just a couple of questions. I'm assuming that departmental budgets are based at least somewhat on past experience as well as current need. Would that be correct in assuming that? Like, those are some. I suppose those questions were fairly open-ended that you just dealt with on budgeting and how much money is needed. I'm sure that we look at past experience and as well as department need for things like equipment and personnel and so forth. Is that how the budgets are established?
We do indeed, and just to give you an example, posting people abroad is a fairly expensive undertaking. And we have, as I mentioned, some 1,500 people abroad, including Canada-based staff, locally engaged staff. So it is indeed a fairly expensive undertaking.
Thank you. Could you just elaborate on how the proposed changes will ensure that there's no discrimination based on race, ethnicity, place of origin, and so forth?
Certainly. I think, as I mentioned in response to one of the other questions, one of the important considerations that we will need to take account of as we develop the instructions is our range of obligations and commitments internationally and domestically. Domestically, we have the Immigration and Refugee Protection Act, the objectives in it that require us to ensure an appropriate balance among the various programs. And we also have our obligations under the Charter of Rights and Freedoms, which ensures that we apply the law and that we exercise all our authority in full conformity with those rights and obligations, which explicitly prohibit any form of discrimination.
Thank you. I think all of us as members of Parliament can speak to their experience with this issue. I know Mr. Menzies next to me spoke of an issue that he's dealt with for some time. We see a lot of, quite frankly, I have experience in my office. I'm not that far from Toronto. I have applicants come in, bring files to my office that they're also working on in other MPs' offices. I know that there's incidents of people reapplying. There's various methods of trying to kind of end run around the system, and various. It's because the system is grinding to a halt. It's because it's taking so long. So I support these motions which are aimed at, or these amendments which are aimed at speeding up the system. Can you just elaborate how people that have applied, current applications, can you talk about how those applications will be dealt with, how the old system will be transformed, and how those people can rest assured that their place in the queue won't be simply forgotten about?
The amendments contain some transition provisions that deal with
you should listen
applicants both pre and post the 27th of February. For those that are in the backlog, that is the pre-February 27 backlog, the minister's obligation is to, and undertaking is to bring that number down as quickly as possible, because it is that enormous amount that is constricting the overall system. So by way of the budgetary amounts that were accorded to the department, we'll undertake a number of activities in terms of letter writing campaigns to confirm people's interests, some of the administrative efficiency measures that the minister talked about in terms of centralized processing, in terms of coding applications, so that we could then refer to provinces certain occupational groups that may match provincial demands. There was the resource issue in terms of buttressing resources in some of our higher volume missions, such as Manila and Delhi, to make sure that they've got some of the tools to chew through the backlog as quickly as they can.
Can you please confirm for me, does the current system force immigration officials to process applications for people that have either already immigrated to other nations or that have in fact died since they've put their application in? Do they remain in the queue and still required to be processed?
We're obliged to process all applications, yes.
Thank you.
Mr. McClare has insisted on a couple of quick questions, so I'll allow him the last couple of minutes.
I didn't that much insist, but you did offer this, Mr. Chairman. Ms. Lyon, you just spoke of ethnic and national origin. Do you have any statistics regarding this on ethnic and national origin of the 925,000 people in the waiting line?
Referring to ethnic or national origin, I was referring to the resources at certain of our missions.
In your previous answer, you mentioned ethnic and national origins. So now you're saying that the department in charge of this 925,000 people has absolutely no statistics on the ethnic and national origins of these people who have applied to come to Canada as immigrants. Is this what you are telling this commission this afternoon?
Regional information, but we do not have ethnic breakdowns.
Vous avez fait cette référence tout à l'heure à l'origine ethnique.
You referred just now to ethnic and national origins with regard to the Charter of Rights and telling us that it won't be against the Charter of Rights. So the best way to ensure that the minister has good intentions is to have this information. Could we get the information on national or regional content in a public forum, and if so, where can we find that information?
That information, some of it is available on our website, some is available in the levels plan, but we can certainly provide the committee with
C'est bien.
that.
Alors, ça serait assez simple donc pour le public.
Very good. So it would be quite simple for the public to do this backlog and the 935,000 cases to make sure that there's no distinction based on national, ethnic, regional or religious standards or others.
most highly litigated departments in the government. So I think if there were to be any suggestion, then there would certainly be challenges brought to bear.
Ma question n'était pas celle-là. Je voulais juste m'assurer.
That was not my question. I just want to be sure that we can follow this, because it's one thing to bring the thing to court, but it's another thing to have proof. So you start with this 925,000. You have documents, statistics, categories, and classes on a national and regional basis, so that as we apply the minister's measures, we can see whether she really did not intend to do this.
Yes, you can certainly see the statistics as to whether or not that is going to imply that there has been any sort of charter breach. That would be an argument that a lawyer would need to construct. But I must repeat that it's certainly our obligation, one that we take very seriously, to ensure that we exercise our responsibilities in full conformity with the Charter of Rights and Freedoms.
Okay. Thank you very much. Now, just before we adjourn, I want to inform the committee that the great nation of Ghana, their Finance Committee, is asked to meet with our Finance Committee Tuesday, May the 6th at 11 o'clock. That information will get to your office via the clerk tomorrow, so I just want to give you that information. That's here, not in Ghana, unfortunately. But nonetheless, with that, I want to call this meeting adjourned.
Mr. Chairman, I did, before the break, I did put a motion in. We haven't dealt with it yet. I would like it dealt with.
The time is gone, and we can deal with it at the next meeting, but the time is gone. Unless there's unanimous consent to extend the hours. No, meeting adjourned. Thank you.